2 days later, the permanent representative of the Russian Federation to the European Union stated in an interview that the operation was a peace enforcement special military operation carried out in an effort aimed at denazification, adding that people had actually been exterminated and that, I quote, "The official term of genocide, as coined in international law, if one reads the definition, fits pretty well." End of quotation. In response to the Russian Federation's allegations and its military actions, the Ministry of Foreign Affairs of Ukraine issued a statement on 26 February 2022, stating that Ukraine, I quote, "strongly denies Russia's allegations of genocide and disputes any attempt to use such manipulative allegations as an excuse for Russia's unlawful aggression." End of quotation. At the present stage of these proceedings, the court is not required to ascertain whether any violations of obligations under the Genocide Convention have occurred in the context of the present dispute. Such a finding could be made by the court only at the stage of the examination of the merits of the present case. At this stage, the court's task is to establish whether the acts complained of by Ukraine appear to be capable of falling within the provisions of the Genocide Convention. The court recalls that while it is not necessary for a state to refer expressly to a specific treaty in its exchanges with the other state to enable it later to invoke the compromissory clause of that instrument to institute proceedings before the court, the exchanges must refer to the subject matter of the treaty with sufficient clarity to enable the state against which a claim is made to ascertain that there is or may be a dispute with regard to that subject matter. The court considers that in the present proceedings, the evidence in the case file demonstrates prima facie that statements made by the parties referred to the subject matter of the Genocide Convention in a sufficiently clear way to allow Ukraine to invoke the compromissory clause in this instrument as a basis for the court's jurisdiction. The statements made by the state organs and senior officials of the parties indicate a divergence of views as to whether certain acts allegedly committed by Ukraine in the Luhansk and Donetsk regions amount to genocide in violation of its obligations under the Genocide Convention, as well as whether the use of force by the Russian Federation for the stated purpose of preventing and punishing alleged genocide is a measure that can be taken in fulfillment of the obligation to prevent and punish genocide contained in Article 1 of the Convention. In the court's view, the acts complained of by the applicant appear to be capable of falling within the provisions of the Genocide Convention. The court recalls the Russian Federation's assertion that its, quote, special military operation, end of quote, is based on Article 51 of the United Nations Charter and customary international law. The court observes in this respect that certain acts or omissions may give rise to a dispute that falls within the ambit of more than one treaty. This assertion of the Russian Federation does not therefore preclude a prima facie finding by the court that the dispute presented by the application relates to the interpretation, application, or fulfillment of the Genocide Convention. The court finds, therefore, that the above-mentioned elements are sufficient at this stage to establish prima facie the existence of a dispute between the parties relating to the interpretation, application, or fulfillment of the Genocide Convention. In light of the foregoing, the court concludes that prima facie it has jurisdiction pursuant to Article 9 of the Genocide Convention to entertain the case. Given the above conclusion, the court considers that it cannot accede to the Russian Federation's request that the case be removed from the general list for manifest lack of jurisdiction. The power of the court to indicate provisional measures under Article 41 of the statute has as its object the preservation of the respective rights claimed by the parties in a case, pending its decision on the merits. It follows that the court must be concerned to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. Therefore, the court may exercise this power only if it is satisfied that the rights asserted by the party requesting such measures are at least plausible. At this stage of the proceedings, however, the Court is not called upon to determine definitively whether the rights which Ukraine seeks to protect exist. It need only determine whether the rights claimed by Ukraine on the merits and for which it is seeking protection are plausible. Moreover, a link must exist between the rights whose protection is sought and the provisional measures being requested. In the present proceedings, Ukraine argues that it seeks provisional measures to protect its rights, I quote, not to be subject to a false claim of genocide and not to be subjected to another state's military operations on its territory based on a brazen abuse of Article 1 of the Genocide Convention. End of quotation. Ukraine contends that it has a right to demand good faith performance of obligations under the Genocide Convention by the Russian Federation in accordance with the object and purpose of the Convention. It states that the Russian Federation has abused and misused the rights and duties stipulated in the Convention, and that the, quote, special military operation, close quote, of the respondent is an aggression undertaken under the guise of the duty to prevent and punish genocide, enshrined in Articles 1 and 4 of the Convention, and that it frustrates the object and purpose of the Convention. The Court observes that, in accordance with Article 1 of the Convention, all parties thereto have undertaken to prevent and to punish the crime of genocide. Article 1 does not specify the kinds of measures that a contracting party may take to fulfill this obligation. However, the contracting parties must implement this obligation in good faith, taking into account other parts of the Convention, in particular Articles 8 and 9, as well as its preamble. Pursuant to Article 8 of the Convention, a contracting party that considers that genocide is taking place in the territory of another contracting party may call upon the competent organs of the United Nations to take such action under the Charter of the United Nations as they consider appropriate for the prevention and suppression of acts of genocide or of any of the other acts enumerated in Article 3. In addition, pursuant to Article 9, such a contracting party may submit to the Court a dispute relating to the interpretation, application, or fulfillment of the Convention. A contracting party may resort to other means of fulfilling its obligation to prevent and punish genocide that it believes to have been committed by another contracting party, such as bilateral engagements or exchanges within a regional organization. However, the Court emphasizes that in discharging its duty to prevent genocide, every state may only act within the limits permitted by international law, as was stated in a previous case brought under the Convention. The acts undertaken by the contracting parties to prevent and punish genocide must be in conformity with the spirit and aims of the United Nations, as set out in Article 1 of the United Nations Charter. The Court can only take a decision on an applicant's claims if the case proceeds to the merits. At the present stage of the proceedings, it suffices to observe that the Court is not in the possession of evidence substantiating the allegation of the Russian Federation that genocide has been committed on Ukrainian territory. Moreover, it is doubtful that the Convention, in light of its object and purpose, authorizes a contracting party's unilateral use of force in the territory of another state for the purpose of